Before we get to the constitutional problems, what's the statutory authority to appoint the task force?
So there are two sources of authority, Your Honor. The first is that under the Reorganization Act, the Secretary has the power to exercise all functions and duties of the Director. And the Director, under 299, has the authority to convene the task force.
Isn't that an odd delegation? Normally, it would be the superior or the principal officer who would have the authority, who would delegate it to subordinates.
Well, it's not just a delegation, Your Honor. The Reorganization Act was in place when 299 was enacted, and so when Congress passed 299 and said that the Director could convene the task force, that meant that the Secretary could convene the task force.
So the word you're using, the word convene?
Yes, Your Honor.
Well, I think that normally connotes just calling a meeting or something. The court was convened this morning. The chief didn't appoint any of us.
So I agree, Your Honor, that convene doesn't necessarily connote appointment, but there's no other language in the statute that specifies who will appoint these members. And in light of that, convene is most naturally read to mean convene and select the people who will serve on the board. And that's clearly true before the ACA. Before the ACA was enacted, it's clear that the Secretary and the Director had the power to convene to appoint these individuals.
But appointment would not be an issue if they had no authority to require anything of others. It's just advisory.
Well, not as a constitutional matter, but as a statutory matter. And I took your question to be, where is the statutory authority to do this? Before the ACA, it had to be the case that the Secretary and the Director had the authority. It would not be constitutional for the President to select and the Senate to confirm these individuals before the ACA, because before the ACA, everyone agrees they weren't officers, and the Senate has no constitutional power to have any role in the selection of a non-officer. So the only way to construe the statute before the ACA is that the Secretary and the Director had the ability, and nothing about the ACA changed that.
Can you give me an example of another body that's selected this way? Just with using the operative term convene, and that had been, and that the authority comes from through a subordinate to the principal.
So not off the top of my head, Your Honor, but again, as a statutory matter, if we're just talking about how the statute should be construed, there is no other provision anywhere in the code that says who will pick these people. So the most natural way of reading a provision that says that he shall convene the task force is to also select the people who will serve on the task force.
Don't you rely